This is why I really just
Just a
don't feel
minute.
like I should work with them.
Just a minute. Mr. DeMayo,
Yes, Your
sit
Honor.
down and pay attention. You're in a court proceeding. Don't get up
Yeah.
and walk away because you didn't like something somebody said. You're asking for her grace to let you stay until the end of May, and then you act like that.
I'm sorry. I do.
Otherwise, we can have a hearing and you can be out in 10 days and the sheriff will put your stuff out in the street.
Right at this moment, Your Honor, I've not heard from either one of them. They are still living in the home. I don't know that this matters or not, but they haven't paid rent. They owe rent in $5,700. We would like to continue with the eviction.
Where is she working?
She works at Lippert Components.
All right, well, I don't know if she can hear me or not. I can't hear her. Miss Morse, can you hear me? All right.
Everything should be good.
Well, she's not quite here. At any rate, Ms. Corpening, this was filed as a demand for termination of tenancy. The defendant indicated that they were going to or had contacted legal aid. He also indicated they were willing to move, but did not want to have an eviction on their record. What's the current status?
Right at this moment, Your Honor, I've not heard from either one of them. They are still living in the home. I don't know that this matters or not, but they haven't paid rent. They owe rent in $5,700. We would like to continue with the eviction.
When was rent last paid?
Last rent was paid 9/26 of 22 for September's rent.
Mr. DeMille, what's your position?
Your Honor, my position is this. We have the money in an account. We're honestly not willing to give it to her because of all the things we've had to put up with since we were here. And I know that we do, you know, you pay what you owe. I firmly believe in that. But also, I believe in fairness also. And I also believe that she's been overcharging us. Like, okay, we did a lease when we first.
Stop. This isn't about payment of rent. She just said as an aside. They're attempting to terminate your tenancy.
Right. I understand that. And I'm okay with that. I'm sorry.
Right.
Go ahead.
Are you guys prepared to move?
I believe in fairness.
Why they're
Also,
withholding rent,
Last rent was
talking
paid
about overcharges, lack of lease renewals,
9/20
arbitrary
rent.
rent increases. The judge cuts him off immediately. This isn't a non-payment case where rent disputes
Mr.
matter.
DeMille, what's
The
your
landlord
position?
filed for
Your Honor, my
termination of
position is
tenancy,
this.
not eviction for
We
unpaid
have
rent.
money
That's
in
a
an
critical
account
procedural distinction.
because of all
In
the things we've
termination
had to
cases,
put
the
up with since
landlord
we
is
were
ending the
leaving
tenancy
that.
for
But
lease
also,
violations, not because
26
rent
of
is owed.
22 for
The judge
September.
mentioning the $5,700 was just context, not the legal basis for eviction. The tenant's complaints about rent
we're
fairness are
honestly not
irrelevant to
willing
whether
to
they
give it to her
violated
but
lease
here,
terms.
and I know that we do.
Wrong defense
You know,
for the
you pay
wrong
what you
case
owe.
type.
I firmly. Yes, Your Honor. Like I mentioned last time at the hearing, we've been looking for a place. We've been looking for a place since we moved in here. We moved into very subpar living conditions. The rent's been going up. We haven't been having a lease redone. There was no agreement. She just upcharges the rent whenever she feels like it. She's fake evicted us 3 or 4 different times. Just the emotional stress over that. Like, we've had an eviction before. We know what it's like to be homeless, to be put out in the street. And it's really difficult when we get settled somewhere, like for somebody to keep holding that over your head when there's no actual proof or reason for her to do any of that stuff. She claims destruction.
We haven't gotten to that part yet.
Right.
But if you're willing to move voluntarily, then maybe we can.
Oh, I am, Your Honor, and like I mentioned at the last hearing, we've been actively and aggressively trying to move for at least the past year. Like, before she even tried to hit us with this, whatever she's hitting us with now, I can't even keep up. But we've been trying to move. We actually have been trying to move since we moved into this trailer because it is so disgusting and subpar living conditions. We've been trying to get out of here since COVID started. It's just been so extremely difficult to find a place, and we weren't trying as aggressively in the beginning of the year. But once all this started happening, we actively and aggressively we're trying to find some place to move. There's just simply no places to move, and the ones that are, available. They want all these requirements that, like, she has an eviction on her record. So like back in 2018, which it's been a while, but they keep holding that over her head. And then like, it's just been a number of things with the housing market the way it is, and there's no available places to move. So we actually did get lucky since our last hearing, though. We did get lucky and actually find somewhere that was willing to take us in, but they're not going to be available till May 1st. So that leaves like a pretty significant couple weeks that we're going to have to figure something out. If so, like, it would just be my request that, and if it is okay with everybody involved, and the mercy of the court or whatever, that we be granted at least until May 1st. But I mean, if we can't work that out, then I guess I'll just have to figure out what we have to do.
All right. Well, the law says you would have 10 days from today, which would be April 13th. So
Right.
they would have to give you an extra 17 days. Mr. Bush or Ms. Corpening, do you have a position regarding that if they were to move voluntarily by April 30th?
I defer to Chris on that. She can respond to that, Your Honor.
Well, Your Honor, I've always tried to be fair with my tenants, and although I'm not going to stand here and bash him the way he's been bashing me, it is not subpar. I have not raised the rent arbitrarily.
Okay.
We have put out newsletters as to when the rent was raised properly, the way we always have. He can sit there and say we haven't, and yes, I did put out an eviction prior to this one. I tried to work with them, but could you please stop? This is why I really just don't feel like I should work with them.
Just a minute. Mr. DeMayo?
Yes, Your Honor.
Sit down and pay attention. You're in a court proceeding. Don't get up and walk away because you didn't like something somebody said. You're asking for her grace to let you stay until the end of May, and then you act like that.
I'm sorry.
Otherwise, we can have a hearing and you can be out in 10 days and the sheriff will put your stuff out in the street. They allege your kids are dancing on the roof. They're breaking windows out. There are other allegations that have led them to terminate the tenancy. You haven't paid the rent since September and you're full of indignant disgust. I don't know. These properties are inspected. There's a waiting list of other people to move in. If you move out,
the tenant got up and walked away from the screen while the landlord was speaking.
They allege your
The judge
kids are
immediately
dancing
calls
on
it
the
out.
roof.
You don't leave during court proceedings just because you don't like what someone's saying.
Paid the rent since
Then the judge lays out the reality. They haven't paid rent since September. There are allegations of kids dancing on roofs and breaking windows, and they're asking the landlord to give them grace to stay until the end of April instead of the standard 10-day move-out. The properties are inspected. There's a waiting list to move in. The landlord doesn't need to accommodate them. When you're requesting a favor and then disrespect both the court and opposing party mid-hearing, you just burned your leverage.
There's somebody ready and willing to move in. You're asking for a consent to allow you to move out at the end of April, which is some grace, and then you disrespect me and her like that. When she was speaking, if you were in the courtroom, you wouldn't get up and walk out and get a drink or go to the bathroom in the middle of the proceeding. So let her finish what she was saying. I'm not sure where we're headed for a hearing and a 10-day move out or a consent to the end of the month. Go ahead, Ms. Corpening.
Your Honor, at this point, I'd like to do a 10-day and a move out.
Well, then we have to take testimony and we're going to have to present evidence regarding these alleged lease violations. Are you ready with witnesses to testify in that regard?
I believe that Chris Corpening has all of the relevant testimony, Your Honor.
All right, I've got somebody else here. All right, Ms. Corpening, would you please raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, I do, Your Honor.
All right, you filed a notice to quit with a termination of tenancy in December. The notice is somewhat vague, in fact, quite vague. It just says destruction of property. That's all it says. Seeking possession due to destruction of property. And then the complaint to recover doesn't tell me much either. So this is a very weak complaint. If legal aid was here, they'd probably make you file a motion to file a new one.
Now the judge shifts to examining the landlord's paperwork. The notice to quit just says destruction of property with no details. The complaint doesn't provide much either. The judge calls it a very weak complaint and says if legal aid were representing the tenant, they'd probably file a motion to dismiss based on insufficient notice. That's a procedural defect. Tenants are entitled to know specifically what they're accused of so they can prepare a defense. Destruction of property doesn't tell them when, where, what was damaged, or who did it. Even though the judge is clearly frustrated with the tenant's behavior, defective notice is defective notice. Process matters even when the judge doesn't like the defendant.
What does that mean, destruction of property?
Your Honor, I have pictures of their child up on a roof. They climb the roofs, they break windows. Their child is not the only one who has done this, but I have evicted another individual who was involved in this as well. They're constantly walking in the middle of the road.
Let me stop you.
Sure.
You're not willing to give 17 days of grace. So, Mr. Bush, she's your witness. I'll let you ask the questions.
Chris, what is your position with Memory Lane Mobile Home Park?
I'm the property manager.
Okay. And are you involved with a tenancy involving Patricia Morse?
Yes.
And is that lot 173?
Yes, it is.
And that's located in St. Joe County?
Yes.
Okay. And as part of your duties, have you had to deal with violations of the rules and regulations?
Yes, I have.
And you started to testify before, but can you share with the judge what the major problems have been with the tenant and their occupants?
It's the disbehavior of the child. Him and a few other children have been climbing on roofs and breaking windows and disrupting other tenants. They were out with BB guns a while back. That has been a while, and that has since cleared up. But we've had them on roofs. We've had broken windows. They're just walking down the roads, flipping people off, no differently than Mr. DeMayo flipping me off every time he drives by. It's just, I don't feel like I need to tolerate that.
Well, all right. The complaint says destruction of property.
Yes.
I don't have it. I've got kids on roofs and alleged broken windows. So, John, let's see if we can narrow this down as to when and where.
Can you follow up? Can you follow up on what property has been destroyed?
Meaning which lot numbers or what?
Yeah, I mean, if it's is it windows? Is it buildings? Is it materials? If you can explain what's been broken or destroyed.
It's windows. It's a screen door, skirting, and they painted all over the side of a home and a shed.
Is this their lot 173 or is this other properties?
Other properties within the park.
Okay. And have you received complaints from other tenants regarding the behavior of those children?
Yes, I have.
And do you feel that in order to protect the integrity of the park, you need to have them leave so you can have a more safe and less turmoil in the environment there?
Absolutely.
Your Honor, I have no further questions.
Well, the problem is, just a minute, Mr. DeMayo, I'll give you a chance to speak.
Yes, sir.
You can't just throw some spaghetti up against the wall and hope it will stick. I don't know when, where, what was damaged, how old these kids are, whether they're 4 or 14. You filed a very poor notice to quit that says destruction of property. That is the only thing that they're on notice for, as to terminate their tenancy. That was in December 21st. There's no addendum, there's no attachment, there's no nothing. Then they get the notice to quit or the complaint and it doesn't say anything. that just says notice to quit. So this is weak, and you need to have more specificity.
Your Honor,
Judge
there's
breaks
somebody
down
else.
exactly why the
I
landlord's
don't, I'm
case
so
has
like
problems.
to
There's
comment
testimony
on some
about
of the
kids
things
on
she was
roofs,
saying because
broken windows,
yes,
BB
sir.
guns, walking in the
That's not gonna
road,
help
flipping people
anything.
off, but no
Know is if
specificity.
you will agree
When
to
did these
move
incidents
voluntarily
happen?
by the
Which
30th
properties
of
were
April.
damaged? How old are the kids?
Did a
4 or
flyby.
14?
She
And the
showed
notice to
up, I
quit
couldn't hear
filed
it.
December 21st
So
says
she's
only
subject to
destruction of
default. So you
property
may-
with no addendum,
I told
no
you at the
attachment,
beginning.
nothing else. The complaint doesn't add
Because
detail either.
that
The judge
that's
uses the
the
phrase
things
throw
that you were
spaghetti
saying
up
about.
against the
All you're
wall
doing
to
is
describe
making each
vague
other mad.
allegations, hoping something
Well,
sticks.
All I want.
That's not how eviction cases
Yes,
work.
Your Honor, I will.
Even if
All right,
everything
now, Miss
alleged
Morse
is true,
here,
without proper
I
notice
don't know whether
specifying
she could hear
violations,
me. That
the landlord
doesn't
hasn't
count
met
as an
procedural
appearance
requirements.
decision for both
Weak
of them.
pleading undermines
Here
a
she
strong
is
case.
again. They were agreeing to move voluntarily by the end of the month, but Mr. DeMayo was so disrespectful, he decided, screw it. So if you want to evict them, you got to do it right. You got to give me more than some vague allegations that somebody who did something to somebody. So you can either agree to let them move by the end of the month, or we can continue this for a proper hearing at a different date.
I don't want them to be homeless. If they're telling me they're going to move, I'll give them the concession and let them move by the end of the month.
All right, Mr. DeMayo, you got your hand up like we're in school, but I'll let you speak.
I apologize. I apologize, Your Honor. I'm sorry. I didn't know you were still talking. I apologize.
All right, well, you agree to be out by April 30th.
Yes, Your Honor. I also like to comment on some of the things she was saying because that's the things that you were saying about the. Yes, sir.
That's not going to help anything. All you're doing is making each other mad.
Well,
all I want to know is if you will agree to move voluntarily by the 30th of April.
Yes, Your Honor, I will.
All right. Now, Miss Morse did a flyby. She showed up. I couldn't hear her. I don't know whether she could hear me. That doesn't count as an appearance. So she's subject to default. So you're making this decision for both of them. I told you at the beginning. Here she is again.
Your Honor, there's somebody else. I'm sorry. It looks like there's somebody else.
He's the next case.
Oh, okay.
We have several set for today. He's in dire straits too.
I apologize, Your Honor. I'm new to this whole Zoom court thing. This is my first time.
Miss Morse, the other named defendant, finally appears on screen after disappearing earlier when the judge couldn't hear her. When she pops back on, there's someone else visible in frame. The tenant explains it's his first time doing Zoom court and apologizes. But this highlights the other issue the judge mentioned. Miss Morse treated this hearing like an inconvenient interruption during her workday rather than a proceeding that could result in her eviction. She's barely present, literally and figuratively. When defendants don't take hearings seriously and landlords file defective notices, the judge ends up managing dysfunction on both sides while trying to reach a fair outcome.
I told you if you do reach a consent judgment with the court, you'd waive the rights listed above, but have the following additional rights. The judgment could not be enforced until 3 business days had passed. You could move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. Miss Morse, can you hear me? Miss Morse? Instead of treating this like something important where she's about to be evicted from her house, she's treating it as an inconvenient nuisance that happens in the middle of her workday. So she's not here, and I guess we'll treat her as not appearing. Anyway, so if you agree on behalf of you and her to be out by April 30th, I will have Mr. Bush prepare a consent order for dismissal. If you don't move by that date, you're subject to being evicted on the very next day, May 1st. You understand?
I do. I do understand, Your Honor, and I also wanted to say, like, with my meeting with legal aid later on, what do you suppose I do about that then? Like, if I talk to them and they say maybe, like, I would really like to consult with them before I make a decision,
you
but like,
have 3 days to move to set this aside if you misunderstood what you consented to.
okay. So what you're saying is if I consent right now and then I talk to legal aid, I have 3 days to undo what I agreed to?
But you have 3 days to make a motion to undo what you.
Right.
Now, all right, I don't want to get jerked around. I don't want to jerk them around. They are
Right.
prepared to let you stay till the end of the week. Till the end of the month. I've already given you one adjournment. I'm going to be gone later in April. And so you need to tell me whether you agree to this or not. You can still talk to legal aid, and you can move to set it aside, but I'm not very inclined to do that. You told me you've got a place to move to on May 1st. This would not put another eviction on your or Miss Morse's record. And so you can still consult with them. But Miss Morse, can you hear me?
Yes, I can hear you now.
Do you agree to move by April 30th?
Yes, sir.
All right.
I
Mr.
do.
Bush will prepare what's called a consent order of dismissal. And it will enter. Then you've got till the 30th, and you also have the rights I advised you in the meantime when you consult with legal aid.
Okay.
She had to give you some concessions she didn't really want to do. So there's some give and take on each side here.
Okay.
Miss Morse, you need to treat this more seriously than you have. I understand you don't want to miss work, but this isn't ideal, but we did finally hear your position on this. So I'm going to remove you and Mr. DeMaio, and Mr. Bush will prepare a consent order of dismissal with a move out date on or after April 30th. All right, Mr. DeMaio, best of luck.
Thank you, Your Honor, and I do.
Thank you, Judge.
Thank
you, Your Honor.
you.
The judge closes by getting consent from both tenants to move out by April 30th. He tells them they can still consult legal aid and file a motion to set aside the agreement within 3 days, but he's not inclined to grant it. They have a place lined up for May 1st. This keeps an eviction off their record, and the landlord is giving them 17 extra days beyond the standard 10-day move-out. Both sides made concessions. Landlord withdrew the eviction despite weak notice. Tenants agreed to leave without contesting violations. The judge controlled the outcome despite procedural defects on one side and disrespectful behavior on the other. Got them to a consent order when neither party's conduct warranted much grace. Case resolved without trial. If you found this breakdown helpful, hit that like button and subscribe for more courtroom reaction analysis. Drop a comment if you think the judge made the right call here.